I'm so glad that Trump's administration is in. Otherwise, I was sure I would be going to a gulag and within 12 or 14 months behind these fascist idiots that were in the office, holding office last year.
Fani, you know we cannot ever do a show without mentioning her. So recently, the court, a judge, disagrees with her. A judge strongly rejects absurd and legally baseless effort by Fani Willis to avoid subpoenas for documents and testimony about Trump RICO prosecution. And this is for the Georgia Senate committee who subpoenaed her twice now. A court in Georgia shut down a request by Fulton County DA Fani Willis to squash subpoenas issued by state legislator intent on quizzing the prosecutor about her and her office efforts to investigate and prosecute Donald Trump.
The big mouth idiot flaunched her way up doing that snake charm thing with her head and said she decided she was going to testify when Judge McAfee was trying to explain to her, hey, it hasn't been ruled upon as to whether that's necessary. Well, I decided. She went up there and she did one of the dumbest crook things I've ever seen. So what's going to happen is we can imagine, in fact, I'm sure he is, Attorney Wade has been singing like the proverbial canary, and he's been exposing a conspiracy to go after and take down Donald Trump. Now, in getting somebody indicted, prosecuting somebody is not illegal. But even if you do that in a legal fashion and you have a prior agreement with others to take him down, because then that becomes a conspiracy and that's a felony. So when there's a felony conspiracy, what happens is the rules of evidence change. And if any one person who is privy to this agreement commits any one overt act, then all of them get wrapped up in this criminal cabal and the standards of proof change. So we have the federal investigation that's ongoing relative to violating federal laws. And we also have one that's ongoing in Georgia relative to the violation of state law. So I think she's in trouble, and she's already gotten on the stand. And what she testified to, she said she had $15,000 cash in the cookie jar, but yet at the same time that she had this cash in a cookie jar, what goes on? She's told IRS under penalties of perjury that she doesn't have $8,500 handy to pay off the taxes that are due. So they give her an installment payment plan. So now she's made under oath a refutation of her assertion that was also subject to penalties of perjury that she didn't have the money. And then that whole thing about the cash transactions, see, in spite of her whining from some pimp preacher pulpits in Atlanta that she was being victimized, there was nobody she had to answer to when it came to approving Wade's fee claims. He got paid $720,000 for doing, in my estimation, a scant amount of work in a criminal case at that point. And Lord knows I have handled enough criminal cases as judge, defense lawyer, and prosecutor to know what it's about. And to put you in perspective, the Attorney General Bondi of the United States, for everything she does handling all of the legal business of the United States, she gets about $380,000 a year. In other words, about half what he got for a scant amount of work. The President of the United States doesn't even make what he made. It's less than $500,000, somewhere around $460,000, give or take. And the Supreme Court Chief Justice for Georgia doesn't make but like $240,000 a year. What's going on is their scam was this. One, they're laundering money, allegedly. And that's why all of the cash transactions. And the other is this. because in spite of her protestations from pulpit pimp pulpits in some of the churches that are pimping the black congregations in Atlanta, there's nobody she has to answer to when it comes to approving what somebody submits as a claim. So theoretically, if she hadn't opened her dumb mouth, she and Wade could have probably split between $6.5 and $8 million. That's what she would have approved as his claims, and they could have just split it because they were doing this cash thing. And by the way, there are some filings in his divorce proceedings relative to the question she specifically gave a negative answer to. Did you ever travel to D.C. with or spend any time with while in D.C.? And those evidentiary admissions in the divorce proceedings are going to damn her. And also, what seems to have been going on up in D.C. is, to put it in layman's terms, Fani, Wade, Letitia, Bragg, Smith, and Harris were plotting to get Trump, and that's a conspiracy. So you wind up going from vice president down to state and federal prosecutors getting caught up in a conspiracy matter.
So it says the focus of the committee's investigation is how Willis spent public funds on her failed racketeering and election interference investigation into 45 and 47 president, and whether any funds earmarked for other purposes were improperly diverted. A subpoena was issued by Georgia State Senate in August of 2024, but appeared superfluous at first. The prosecutor was slated to appear and speak under oath at a public hearing held by the committee that September, but ultimately she was a no-show.
So that means she's in contempt of the subpoena if they choose to deal with it. And since the legislature is now in session, they can direct the sergeant at arms to physically arrest her and bring her forth. There is $10 million in question, $7.5 million for catching up on delinquent prosecutions, $2 million for sex crimes prosecutions, and $1.5 million dealing with juvenile matters. And that $10 million seems to have disappeared. So Georgia law seems clear to me, and I'm not saying this as an attorney, it's more like the professor, that the state legislative committees and the legislature have the right to demand an accounting for any monies that they appropriate to somebody's charge. And that's Fani. What did she do with the money? Where did it go to? So one of the things they're bringing up is you diverted some of this $10 million that's out there that you can't account for to use to prosecute somebody that you conspired to get and use what has been colloquially called lawfare. It's an excellent term. See, what they are doing, well, what they were doing is forbidden by the Bill of Rights, the first 10 amendments. The 14th Amendment applies the Bill of Rights to the states, not just to the U.S. government. So they apply to Georgia. So what is going on is, in violation of the Bill of Rights, you set out to target somebody and find something to destroy them, disable them, or inconvenience them, or bankrupt them for political or economic purposes. That is wrong-headed. That's totally against the whole theme of the U.S. Constitution and the laws of this nation. And it has been recently termed lawfare because very seldom in American history has anybody been so egregious in trying to do that. So it's subject to ballooning because Big Mouth got up there with that upside down backwards pink orange dress and ran her big mouth off up there on the witness stand trying to be sassy.
Right. So,
but one thing, they can compel her to appear, but She still is a citizen. She can and she should evoke her Fifth Amendment rights to remain silent. I decline to give evidence on the grounds that it may tend to incriminate me, which sounds hellacious coming from the chief prosecuting official in one of America's largest cities.
So in January, the embattled DA filed a new motion relying on a wholly separate argument. Willis argued in 2024 subpoenas were mute and should be squashed or dismissed entirely because of the November 2024 general election necessarily resulted in a brand new General Assembly being sworn in. However, the state senators, for their part, quickly made sure to reauthorize Calcert's committee. But Willis essayed the details of how that reauthorization occurred, precluded the subpoenas from having any real staying power because technically the present committee is a different committee than the one that issued the original subpoena. So she's trying to dismiss it on a technicality.
That doesn't watch. That's an asinine first-year law student bullshit argument. In other words, if you took what she's saying, let's say we have Social Security. Did this Congress pass Social Security? No. Did the last one? No. Did the one before that? No. The law that sets out Social Security was passed long ago. So since obviously that Congress, House and Senate is no longer around, most of them being, well, all of them dead and long gone, that would mean that Social Security wouldn't exist unless each succeeding administration or each succeeding House and Senate congregation decided to say, well, it doesn't work. See, it's the body that does it, not the individual. That is a stupid first-year law student argument. It's not going to wash. It no longer is relevant because the legislative body, as an assurance, redid it. So the point is stupid. That's like what happened. Remember when I was telling you what happened with the Cosby thing way back when as to why that conviction was not going to stand because of the Fifth Amendment violation? The initial district attorney gave an assurance to the court that had a civil matter against Dr. Cosby that there would be no prosecution. That allowed the civil judge to properly order Dr. Cosby to testify during what they call, he had to testify during the earlier proceedings and give testimony. So the new DA said, I'm not bound by that. I decide I'm going to prosecute him. So we're going to use what he said during this deposition, is what they call it, and use it as evidence in chief against him. Well, it's not the old DA gave him a break. It's the district attorney's office gave him the break. And once he relies on it, you can't go back and undo it. What is it? The king is dead. Long live the king. In other words, this king is dead, but the office of kingship is open and there's a new occupant. So it continues. The body does it, not the individuals. That's the South Carolina thing. Thank you, dear. That's enough. Now,
I want to read this here from the judge, basically echoing what you just said. Fulton, in a 2-page order, Fulton County Superior Court Judge Shukura L. Ingram rejected the argument out of hand, noting this court disagrees. The judge said she was sympathetic to Willis' arguments that the original subpoenas were issued near the end of the last legislative term, and that compliance is perhaps better achieved if subpoenas are issued by legislators early on. Still, the judge cautioned there are merit ways to tie these disputes up in court. If every time a subpoena is issued by a special committee, a recipient can simply litigate its validity and enforcement until the General Assembly reconstitutes, and then they have to start over. This would be an absurd result indeed. not least because this would mean that if the need for a subpoena did not arise well towards the beginning of the term, the General Assembly would be forced to defer issuing said subpoena until the beginning of the next term in order to maximize their window of opportunity to enforce it. This could and will result in lost evidence, fading memories, and general inefficiencies.
Yeah, and the legislative body has an absolute right to inquire as to what happened to the state's money that was turned over to somebody to spend.
And let me finish this last quote from her. Moreover, suppose the production of documents were ongoing during the transition from one term to the other. Would everyone simply have to start over? ? The court's order goes on to say, this court cannot in good conscience facilitate such a result. As such, petitioner's motion is denied.
Well, the judge missed a point I just made. In other words, there's a continuity. It's the legislature for the state of Georgia, and its authority continues irrespective of its immediate or contemporary makeup.
Mm-hmm. Well, that wasn't the end because she went on to say this court.
I mean, she's explaining why she did it, but she didn't have to go that way. All she had to do was say the Georgia state legislature maintains continuity from one session to another.
Oh, she could have shortened it, but you judges, you don't shorten anything.
Yeah, a lot of the practitioners and judges miss some of the very obvious points. They give an alternative which is equally compelling, but you have to.
Maybe she should have included that. Maybe she should have included that as well.
That would have resolved it. In other words, the continuity of the Legislative Assembly is not compromised by the fact that there is a new session in place now. So that's it.
Yeah.
And then everybody goes, oh, yeah, I guess when this legislative body in 1928 passed this, or in 1997 passed that, all of that didn't suddenly evaporate the laws. In other words, you'd say, well, this is a different legislative body because it's no longer the same session, so this law on shoplifting no longer applies. You see how that goes? It doesn't work that way. You put it in the code books, it's there. That's an act of the legislature. It does not evaporate because you get a new legislative body, a new session.
Willis claims the attorney-client privilege to 3 requests lodged by the state senators. The judge suggests those claims are off base.
They are off base. You're a public official. And the damn thing is, we're not suing you right now, George is saying. We are making a demand that these matters of accounting of public funds be explained. So
Willis,
you didn't have to receive them if you didn't want to deal with the caveat that goes along. You have to. You don't have to respond, but that means you have to leave the office, and your successor can say, okay, well, we're going to send the state legislative body what the laws of the state of Georgia require. Now,
Willis also claims the work product privilege, a form of privilege closely related to the attorney-client privilege based on work done specifically in regards to legislation or a trial in response to those same 3 requests. Again,
she doesn't have that right because that's not personal to her. She can only make that personal claim because what? She represents one of the judicial districts in the state of Georgia. She represents the people. Her client consists of the people in that district. The district is the one that embraces Fulton County, Georgia, which embraces a large segment of Atlanta, Georgia. So she doesn't own that.
So again, the judge suggests this privilege does not apply. The judge probes by noting the questions have to do with Willis' hiring of and personal relationship with former special prosecutor Nathan Wade. Finally, Ingram strongly suggests Willis is improperly claiming the law enforcement privilege to one request and all but counsels the district attorney to abandon the current exemption in favor of another law enforcement privilege or an law enforcement material assertion.
Now, I'll give you an experienced position. There is a counter to Willis's argument that she brings up herself. She talks about attorney-client. Well, the client being the people, the attorney being the district attorney for the people in the district, has an obligation to fully disclose and fully communicate with the client. So she has an obligation to disclose to her clientele, meaning the people of Fulton County, Georgia. So she just defeated her own purposes by claiming attorney-client. It's bogus, and it's the last step. And what's going on is she needs to resign, get a good lawyer, not some of the hacks that they've been floating around out there, a real good lawyer, and work something out so she doesn't go to jail too long. Now, in other words, she needs to get her act together before she does too much time.